construed or relied upon as being legal advice for an individual legal situation, or employed for making a legal decision. You will not use any of this information for making a legal decision or performing a legal procedure, and is not a substitute for legal advice and or guidance by a licensed attorney. This private show and or documents are for academic informational purposes only, to be used at your own risk without liability to Christian Walters. By accessing or reviewing this show or using the documents therein, you understand with agreement that, with all rights reserved without prejudice, Christian Walters is not an attorney licensed to practice law in the state of Florida or any other state, and has not given legal advice or accepted fees for legal advice, provided no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties in the preparation or use of herein referenced, and has no interest in any use referenced therein, and is not a party to this or any action arising from, and is only acting in an authorized capacity as liaisons to communications between the parties. By reading and or using this information, you acknowledge and agree that you are not a client of Christian Walters. These documents and or show recordings are incomplete and void without this notice agreement being attached herein by reference, and a breach of this agreement. Upon breach of this agreement, the breaching party becomes liable for admiralty commercial damages of $100 million or more per stultification or impairment per Christian Walters' discretion. Thank you for your understanding.
I'd like to welcome everyone to this Tuesday, January 25th, edition of Money, Banking, and Trust by Moving Titles and Commerce. I'm your host, Christian Walters. Welcome to NTT as New Trust Technology. We're continuing on our search for what equity is. And the law is nothing without equity, and equity is everything, even without law. And those who perceive what is just and what is unjust only through the eyes of the law never see it as well as those who behold it with behold it with the eyes of equity. Law may be looked upon in some manner as an assistance for those who have weak perception of right and wrong, in the same way that optical glasses are useful for those who are short-sighted or whose visual organs are deficient. Equity, in its true and genuine meaning, is the soul and spirit of the law. Positive law is construed, and rational law is made by it. And that's John Bouvier, Institutes of American Law, 1882, Volume 2, Section 3724, Paragraph 4. So as you can see from that statement that Bouvier made, that equity is everything, even without the law. Because equity is the source, it is the soul, it is the spirit of the law. All the law was made from it. And yet we're told today not to go into a court of equity by some of these people out here who are saying, no, you don't want to do that. Well, I'm afraid they are unlearned and unstudied because they have not really studied equity if they say that, or else they're nothing more than agents. Because the law is made by equity, and we need to put on our perceptive glasses so we know what the law is, whether the law is wrong or whether the law is right, and you know that you get that discernment by equity. You must put on the eyes of equity to see the law, what the law is really, because the law is made by equity. It is the God-conscious mind. And it's not so much that I see NTT being a success towards terminating the straw man or anything else like that, or terminating commerce. I'm more excited that equity is a road leading you to a God-conscious mind, a same parallel thinking as God is using. I look at equity as being the interface into that God consciousness, in a better way of understanding that thinking through the 20 maxims. That is the principle in which equity rests. I don't need 23 million plus statutes and codes. I don't need the statutes and codes at all. For if I'm going to be operating with equity, which is really grace, I don't need the 23 million statutes and codes. Because those 23 million statutes and codes plus were made from equity. And if I understand the principles of equity, how equity operates through the 20 maxims, I don't need to operate under the statutes and codes. And when I put those glasses on, now I no longer see deficiently. I see with discerning eyes, because now I have the perception of right and wrong, and I don't need statutes and codes. So why don't we go to Q&A?
Q&A session started.
Press star 6 followed by 1 to raise your hand and get in the queue line. Star 6 followed by 1 to ask a question. Star 6 followed by 1 to raise your hand. State your name, where you're from. Star 6 followed by 1. Anyone to ask a question? One of the questions I've been asked quite a bit is, what is NTT? And right away I can tell that most of those people that ask that question haven't been in a call for very long, and they don't even understand what NTT is all about, and they want to know what it is. Well, NTT in its basic bare elements is it's the merging of two titles, and those two titles would be the equitable asset on the equity side and the liability title on the public side, which is the offer that they send to you for a general deposit. So it's the merging of those two titles under a trust, private trust, which is enforceable in equity. And when you merge a plus asset with a minus liability, you get zero. You get an extinguishment because you've merged the two titles. So that extinguishment, I hate to use the term payment because payment is really a debtor-creditor term. It's merging under trust, which has likeness of a payment. And if I can get you to merge the titles and achieve the very same thing that debtor-creditor would in its offset, set-off, and I could also go and pull out the main problem, which is going to hit you in the end anyway, then why wouldn't you do it? Because your immediate problem is not your problem to save your immediate house, although I understand that that's, nobody wants to be thrown out in the street and everything else, or nobody wants their car taken from them or whatever, and I understand that, but that's not your bigger problem. Your bigger problem is kind of liking it to, we're on this Titanic that is going to sink because they're going to take your house, but in reality, the whole world is going to hit another planet and become totally destroyed. So what is the purpose of saving the Titanic when the whole world is going to perish? And that's what it's like. When you use the debtor-creditor realm under the auspices of a -1 added to a -1, or creating a debt instrument and adding it to an existing debt and think that pays for anything, it's debt upon debt. And when you add a debt with another debt, you get double debt. You don't get extinguishment. You don't get zero account. You get -1 plus -1 equals -2. Now you're in double trouble. Sooner or later, all those minuses adding up are going to be so burdensome for everyone that everything collapses. And that's when the whole planet destroys, self-implodes. But as you keep on trying to solve your immediate problem with debt paying debt, that's the outcome that's destined for you, destined for us all, unless we wake up and say, hey, we've got to merge the titles and bring the debt to zero through an extinguishment, through a merger of the titles. And that's what basically MTT is all about, merging titles and extinguishment debt, acting as a payment for your debts and obligations instead of mounting the debt up and it being the guillotine that's going to cut your head off in the end. So star 6 for questions, followed by 1. Star 6 followed by 1. Raise your hand, get in the queue line. Anybody have a question? Star 6 followed by 1. Darren, you're unmuted.
Evening, Christian.
Hi, Darren.
Quick question that, especially that we were actually talking about a little bit before, is that there was talking about, and I know this is kind of unrelated, but it does play into the same part, is that let's say that we're in a court of equity, and of course our contention is that as soon as we handed over our trust res via signature equitable asset, is that that was our intent and purpose in establishing our trust. What in the event the special magistrate says, well, why didn't you express it then at that particular time, in the event that there might be siding with the defendant?
Yeah, there's only going to
be a contention or an argument there.
Yeah, there's only going to be two results from that, I would say, or those two scenarios. One would be that the judge would not allow the validity of the trust to take place at that particular time, although I would go for the contention that it would have to be taking place at the time that I maybe gave the notice. But I think in that event, either way, you're going to win, because either the establishment of the trust was established when you handed over the application, or it was formed at the time that you gave the notice, and that became your intent. So
Okay.
either way, you're going to win, because it's still go for the establishment of the trust. And it makes no difference for me whether it was established or whether I established it last month. Because if it was established, then I want my trust res back.
I see.
If you
Okay,
can't
right,
give me the
right.
trust res back, if you can't give me the trust res back, then you're still in breach, and I don't care when the trust was formed, you're still in breach. And I would enforce the breach.
Right, because failure to perform or a duty that is expected because they have come in with the contention that there was an exchange of something.
Correct. And now, even if they sent the trust res back to me past the disclaimer period, they still have the obligation and the duty, even though they send trust res back to me. Now, I believe that's under Corpus Juris Secundum Section 161, where it says, even though the trustee disclaims and is holding on to the res, he's still acting as trustee. Now, that works probably in the reverse. Let's say he sends trust res back and says that he's not trustee also. But if the trust was formed, he still has the duty and obligation under the office of the trust. Just sending the trust res back does not accomplish the performance.
No, but it does signify that he was acting as such.
Yes, but the disclaimer was that the disclaiming period had ended. So it's
okay.
to put in your indentures that you have a disclaiming period, and then upon the such and such a date, which would be, say, 10 days past, that on such and such a day, that becomes the effective date of the trust, and you must have disclaimed prior to that date. Otherwise, the trust is in effect.
I see. So then this way, if he estoppels by acquiescence, you got him either way, coming or going.
Right. Mm-hmm.
Okay. I understand. Okay. Because I just think of, the only thing is what I do at times, I just think of specific arguments that might come up. And especially where, how the courts have operated in the past. And, of course, I just think, in my own opinion, well, especially in the lower courts, I don't know about the federal courts, but with their, I think, limited knowledge of equity, that we'd almost have to be educating them. But then again, if they're bringing in a special magistrate or judge to hear it, he would have to have some type of knowledge, especially where it's been claimed that this is now into a court of equity, that they would have to have the knowledge of that on that particular side. But I think if anything happens that is, let's say, out of character of how the court should act, it's going to be in the lower courts.
Yeah, the court should be acting equitably, but we may have to educate them on equity. So, and that would be in that memorandum in equity in support of your pleading. Okay.
Understand. Okay. All right. That makes sense. Now, what if there is? Let's use a hypothetical. Let's say I had an old corporation that is no longer in existence. It expired. There wasn't a renewal or anything like that. And I had checks sent to me at an old address, but now, because they had no new forwarding address, now it's sitting in the unclaimed property with the state. You know how they do that? They do all the unclaimed property. And now they're giving you a hard time about releasing it, even though really there's no corporation that's in existence. And can you basically claim where they say, well, you can have an administrative hearing on this issue, where I would come in and say, I don't consent. I want an equitable hearing. I want a hearing in equity, because you're still dealing with res, but it would be on the same contention in the same format.
Well, I would put in a bill for constructive trust, or so that claiming some kind of conversion because the state is holding the property illegally. And that would be an imposition of the exclusive jurisdiction, or rather that would be not an imposition, execution of the exclusive jurisdiction, where trust under constructive trust would be enforced. So I'd make the claim that the state was holding the property illegally under and a trust form. Then you'd have your equitable jurisdiction. Still there? You dropped off? Okay. Anybody else? Oh, wait. Let's see if he comes back in. Press star 6 followed by 1. Anybody have a question to get in the queue line? Star 6 followed by 1. Darren comes back on. Star 6 followed by 1. Anybody?
Sorry about that. I don't know what happened.
Okay.
I got blocked.
Back.
Must be Big Brother. But anyway, no. But what I was saying, so would it be the contention that I would create? What you were referring to was the colorable titles via UCC to show the notice of the constructive trust, or are you talking about that and the indenture?
Well, I don't think I'd have to form a constructive trust. I think the court, I'd come back in with a claim that the court would form the constructive trust. I would come back in with a motion or order that the court be forming a constructive trust for the flushing out of where the assets or the proceeds went, because the state has held them illegally and converted them. So I want to find out where they've gone to. Do a tracing.
I see. Okay. So you would. Okay, even though there's not let's just say there's not a court action, you're going back and forth with the state, but they're rebutting it, not releasing the funds.
Okay, well then I'd have court action against them.
Okay, yeah, because if anything, how they're going to act, and I'm just thinking how they act, especially when we're dealing with a lot of state agencies, they're going to be acting administratively under the APA, which of course we don't really want to go into that realm. And I think that's one area that's, I think, very misconstrued from my contention of reading the APA, is really that is a redress, a grievance against any state agency or its agents, and the only position that you can come in is either as plaintiff or respondent. But I don't believe that act was set up where we are to come in as a defendant or a respondent, which is the defensive position, because I don't think that's how that act was set up. I thought that act was basically to hold them accountable.
Which act was that?
The Administrative Procedure Act. That'd be under Title 120, Florida statute, and 5 U.S.C. 500 to, I think, 522.
Right. I don't know if you'd have a way of doing a judicial review or a judicial hearing that would be equitable to impose a constructive trust, or maybe an independent action. I don't know. Right.
Or even do a constitutional challenge on it. Same thing, because it's really a seizure.
Yeah, but the constitutional challenge wouldn't be a constructive trust imposition, I don't think.
No, it wouldn't. No, it'd be on. That's totally on the outlaw side, and I'm I guess converting in my mind. But I'm just thinking, typically, how you would notice them. Would you use pretty much the trust disclaimer? Is that I don't consent to an at-law or an administrative hearing. This action is contrary to equity, et cetera, et cetera, et cetera.
Yeah, that would work. I think putting the switches in, but then the next hearing that got set up, you better make sure that you knew how to come in with the motions and stuff, what you need to set up a constructive trust.
Right, but really what they're doing, they're actually interfering as a third party. Wouldn't you agree in a scenario like that?
Breach trust then. Another charge, breach trust. Right.
But who would have been the acting trustee? Would it have been the original parties that sent you that sent you funds?
I know you gave the example to me. I don't. You said that there was an estate agency that has kept your trust property. So.
Oh, I see. Right. And I'm just thinking of how to show that there was a trust. In other words, let's say, for an example, just using a hypothetical. Let's say you're a mortgage broker. I'm not a mortgage broker. And let's say you were getting residual commissions from XYZ company, and they were paying it to a corporation that was no longer in existence, but they didn't have your correct address, so they just send it to the state as unclaimed funds. So you're telling the state, hey, give me back my money, and they're saying, no, we got to have a hearing and everything else on it. And to me, that shows like an interference between you and the original parties.
It might be construed on your part that is so, but maybe they might have to have, according to their law form, that they have to have some kind of hearing to make sure that you're the party that you say you are, and you have some kind of claim, an actual legal right to that title.
Uh-huh.
So I don't see where that might be so bad.
So, in other words, go in on the administrative side?
Yeah, because if I could prove that I had an interest in that and that was my property, then I should be able to prove that. And maybe that's what
you see,
what is your proof that you have a connection with this property. If you can prove it, then you can probably get it back.
Well, here's something else. I mean, and it's a very big case, specifically down there in Florida, which you're probably very familiar with. Let's see if I can find it real quick, which I found very cool, and it actually dealt with the Florida bar. I think it was Sperry. I think it was the Sperry case where they were talking about that it only applies to administrative agencies. It was a Florida case. I'm trying to find it. There was different. I thought I could have located it real quick, and I guess I couldn't have. But it did talk about that. Oh, wait a minute. Wait. I think I have it. Yeah, the APA does fall under Title V on the federal level, as well as, and each state has the APA on their side, and that's typically a lot of times they're talking about that. That's how a lot of these, even the courts are running. They're running strictly under the APA, where you have an agency coming out against you.
Yeah, but it looks like maybe that might be so, but really all these courts are nothing more than trusts, enforcing trusts.
Right. Since 1933, right?
Right.
I see. Yeah, I was trying to find that case. Boy, that was a good case, too.
They're all trust courts.
I think. Right. So the administrative side is still under trust, though?
Yeah, yep.
Okay. That was really the only contention that I did have. I wanted to find that case so bad for you. I thought I had it at my fingertips, and apparently I looked and didn't see it there. But it did talk about different. I have a bunch of different other cases, but it was talking about that. It was a Florida case. I thought that would be you'd be very interested in that case specifically, especially when a lot of us are dealing with state agencies and in various matters. But that's good finding. I know I got it. It's like it's under my cajillion million files that I have. Oh my goodness. It's amazing how you get so swamped after a while and you have just so many files. It's just ungodly at times. Oh, there it is. Sperry v. Florida, 1963, administrative agents. That's what it was talking about. And that was a good case. I think it was actually a patent case, but they were talking about that really they don't have any jurisdiction pursuant to that. The APA is really only for the agency, or to be used against the agency. It would happen to be about a case about I think a patent attorney, and there was contention regarding that. But that's neither here nor there. But anyway, that was pretty much it. That was the only question. I wanted to kind of throw that hypothetical out there just to see how it looks. Or how that would work, where you're really talking about a performance. It doesn't have to deal with a debt or anything, more of a performance and a duty, or actually even acquiring the trust res back. Seeing how we can lay the foundation just using that hypothetical there.
Okay.
That's all I got. Thanks.
Okay, Darren. Thank you. I guess we got a clear board, so anybody has a question, *6 followed by 1. *6 followed by 1. No questions, anybody? Questions? Texas, you're unmuted.
Yeah.
Hi.
Can you hear me now?
Yes. Hi, Albert.
Oh, how you doing, Christian?
All right. Good.
There's some chat going on about an allonge, and just for your opinion on it, why would we want one?
To become a signer onto something, or add names to something you need to launch, or you run out of room on something that you want to expand it.
Okay. If I've read the Declaration of Independence, and I wouldn't want the whole document. I just would use like a couple of sentences possibly that make my statement clear as to where my rights were granted from. Some other portions of the document, I don't know. When I read it, it looks like it's going to lead you to statutes and code. But if I used that document as an allonge with my claim, and couldn't it be misconstrued?
Everything can be misconstrued. It's whether or not that your intent was, or whether or not who's right, which comes back to enforcement. So you have to be able to enforce whatever your intent was, or else everything can be misconstrued.
Well, if I'm just going to say hypothetically, I use it. I just have a gut feeling that if I do, it's not going to really make much difference as to, if they're going to disclaim or repudiate or whatever in that matter. I think that it's just to use those couple of sentences, or maybe three or a paragraph, would make my intention, would make my direct object as to where my substantial rights come from.
Then
even though
it would be actually from the Declaration of Independence, then it's just like a section out of it, then.
Right. It's just, right. If you use the whole document, like you said, anything can be misconstrued. So if I send that document with my document to that trustee, that's what could possibly happen. I just want to make my claim known, to make them understand, and I'm sure they would.
Well, anybody can claim anything as long as you can be able to back it up with some kind of proof that you claimed it.
Well, the only other document that I would want behind any statement I make pertaining to that effect would be the ancient writing. And who can prove that? You can't.
What, you mean like the scriptures, you mean?
Yeah.
Actually,
ancient writing.
They're so well known, and it's something you don't really have to prove. You could probably just give judicial notice or just plain notice.
You can't prove two documents. You weren't there when they were written. Either one.
Well,
all you can do is make a claim to it.
As long as you give notice that you've claimed them.
Right. Well, that would be inside, I guess, the document I write up pertaining to it, and making the fiction understand that
just like
my rights don't come from them.
Just like it says in the Declaration of Independence, we hold these truths to be self-evident. It's self-evident. The Scripture, the Bible, being the largest published book in the world, is really self-evident. And it becomes just a question of not being able to prove it, or not having to prove it, but to just give notice that I'm claiming it, say.
Well, if I claim it, I don't have to send them an entire book, right?
Yeah, in fact, it's so self-evident that I really don't have to claim it. It's supposed to be that I really don't have to, because it's so self-evident. That's the way things are supposed to be, the foundation anyway. So, but to follow the public forum and to establish a fact, you have to have two witnesses. So I create two records to that fact that I claimed it. So now it's official. So,
well, what you just said, would that require another public notice, really?
Yeah, to claim it, yeah.
So it's got to be stated. So if you make your first UCC1 public notice, you can put that in your paragraph, can't you?
Yeah, if I use the UCC1 and a county to be my two witnesses that I've claimed this Bible, then that's the public record, the two witnesses that proves the fact.
I had another when on the public notices, well, I understand what the trust says, the number, and the number can point to some past act. But I think in this case, when you're claiming a law form, you should publicly state that. And the other question I had was when we've made a mess in debt title. I think I spent a couple of days thinking about that, and I can't imagine them having a record of every little thing I did, but say they do, right? Now, would it suffice? Would it make any? Would it hold weight if I made a public notice that I claim all those debt titles, withdraw those debt titles, and then redeposit all those debt titles as a special deposit? Would that be necessary, you think?
I think I'd want to claim those debt titles to be merged with the equitable asset and no longer and they've been extinguished.
Well, what I'm asking is, I make a UCC1 public notice stating that all these debt titles, I'm claiming them as trust res, and then go to the two threes, and have a record.
I don't know if I want to claim them as trust res. I would want to claim my trust res being the equitable asset, and claim the other debt titles so that I could merge them. And then once they're merged, then they're extinguished.
Okay, well then I guess a 1 and the 3s wouldn't even matter, right? In making a statement, I mean.
Well, that's how we've been using a merger, withdrawing and redepositing a 1, 3, and 3, or 1 and a 3,
right,
depending how you're doing it.
Well, when you send your final docs, you're going to make that statement in I guess I don't know what it would be called. It would be right at the top, or right in the middle, or in the indenture, for that matter. Ordering them to do that merging, you put it in the indenture, and you wouldn't need to have done the public notices pertaining to the merging, do you?
Not unless I had to enforce it.
Just one, huh?
Not unless I had to enforce it. But that's why we do the records, so to set up the evidence so that if we ever had to enforce it, we could go in and enforce it.
Well, remember, we had a thought, a very good one, about doing it all in one swoop. And it's either that whatever we may, like say for instance, we're going to say in our indenture to merge and extinguish all the debt titles of the trust res, and I don't think, I'm just thinking that a 1 and the 3s wouldn't be necessary for that person to have in their hands, that I said the same thing publicly.
Yeah, it's not the fact that it has to be done. It's when I say it's done, then it is done. And I'm sending it to the trustee for him to ledger it properly and give me some kind of receipt back. Now, if he doesn't do that, then he's in breach of the accounting, and although it's already been merged, there's no getting around that, but it's just that he just didn't ledger it into the bookkeeping system because for some reason he's breaching.
And that would be the receiver, right?
No, the receiver doesn't have any thing to do with that.
Well, wouldn't the receiver have someone that would do the, I guess, pushing the paper, to do that act?
You need to look up what a receiver's jobs are, because the receiver is a trustee on a bankruptcy or an insolvency. And if the receiver is in there, he's put in place because he just has to make sure that the assets don't go anywhere because they got to come through him. But the assets are already blocked because they're put in a protective trust anyway. But just for added protection, the creditors have appointed a receiver on top of that just to make sure that they're watching for their for the opportunity when the trust may terminate, that they're going to jump on the assets then. And the receiver is there for that purpose, to block it, make sure it doesn't go anywhere so that they can get their funds.
Well, then I guess I'll stay away from that language and just tell her to do it, let her figure it out.
Yeah, because the receiver has got nothing to do with it other than he's just standing there waiting to get the assets whenever he can, but since there's a protective trust in place, he can't touch them. And he's forever waiting until the day then the trust purpose terminates, so that he could grab the assets. If that day never comes, he may sit there till hell freezes over them. So who is the proper party for the accounting?
I don't care.
Well, that would be the IRS and the individual master file, or the individual business file, because that's where all the records are kept, where the assets are supposed to be known.
It's this part of the process, that they do behind the scenes that, we barely have any knowledge of it. And what I'm going to do is just stay away from that language and just, tell that person, the trustee, to just get it done. I don't care who she uses to do it. I mean, if the IRS is the one that is holding the cat, tell her. I'm not going to tell her through the IRS. Let her figure it out.
Who is the trustee?
Well, all of them are trustees, but in this case, it's the one that has trust res in their hand.
And who is that?
Well, this one would be the person that I send the docs to. I'm making him, her.
Okay, that's on a case or an individual basis. But you were talking about the receiver, and the receiver is supposed to be the one on the insolvency. And that's pertaining to the straw man, the trust account, the master trust, right?
I think, in my case, the less I try and define who does what, I'm just going to stick with the trustee and point to that trustee to do these things and show that person I have the right to tell them to do these things and the right to have it done. And I'm not going to worry about if the guy that she has it done or if he, whoever it is at that end, does it. Matters not to me. The fraud has to stop.
Yeah, but if I don't have the right party, that's one of the first things we're talking about, the correct parties. If I don't have the correct party, then I don't have the right parties joined, and it can't be effective until I got the right party.
Well,
so it's important to have the right party.
That's true, but see, this is the big one, the big party. Okay. Everybody underneath them.
I was asking if that pertained to the big party that's pulling out the master root, or the straw man account, or the trust account. Then who's the trustee?
Well, tell me. Who do you think is? I mean, I one time thought it was the secretary, and well, that kind of panned out to nothing. So this one here is the other signer on the ledger.
We need to think about, who is the trustee on this master trust?
I would think it'd be the ones that sign the ledger, the dollar bills, and one of them has to handle the private side. One of them has to be plus, the other one has to be minus. What do we do? Put a wording in there that if you're not the guy, find the guy?
Yeah, I would put that caveat in there, or at least notify me that they got the wrong parties, and then I would start looking for someplace else. That's a very pertinent question. Who is the trustee on this straw man trust account?
Well, we know who the accountants
and
are.
That with 100% certainty, sure wouldn't be doing this.
Well, you know what? I can't be 100% certain of anything.
Well, I think you can have a pretty good logical explanation of what direction to go in, because it becomes apparent after enough study that who the trustee really is.
Well, who is the real trustee, in your opinion?
I mean, there's plenty of information out there, and from that information, you come up to one conclusion: who the trustee is.
You know what? I don't get if you're asking me a trick question or
no, it's a trick question.
Serious.
Who's the guy's name? That's the thing. There's no trick question. Who's the trustee on the of the trust? Because they have you, the trustee.
Yeah, well, I make the corporate the trustee.
Under a misconstruement, you're trustee.
Right.
All we have to do is think back to 1933 when all the assets were put into deposit in. The people were supposed to be the beneficiaries, not the trustees. But everything's been misconstrued since then, and you're construed to be the trustee, liable for all the payments. But there's a real trustee. Who's the real trustee? Think about it for a while.
Oh, you got me thinking now.
It's not the receiver. The receiver is a different purpose.
Yeah,
the receiver is there for take care of the creditor's assets, to make sure that the assets don't slip by anybody, they slip out of their hands. That's just their insurance, their protection. They're putting a receiver on that to watch out for all their assets. Now, from 33, a protective trust went into place, and they put all the assets into protective trust. On that trust has to be a trustee. The receiver sits there as the block to make sure that the assets don't go anywhere. But there is a true trustee on that assets, and it ain't the receiver.
No, I didn't mean that at all. I just thought that maybe whoever they appointed to do the accounting, would be called that. But
well, the IRS, the accountants, they're the ones appointed to do the accounting. They're not the trustee either.
No, I didn't think they were. It has to be the bank.
What bank? Back in 1933? Banks is the bank.
A
lot of trusts have money in banks. Banks aren't maybe the actual trustee on a different trust. Just think about it and roll around a while.
Yeah, I'm on a roll. Thank you.
What else? Anything else?
I'm still rolling. In mud. Well, maybe answer, put me in the right direction here. As long as I'm pointing in the right direction, I don't care who I fire it off.
Well, who do you think it is?
Well, I would think that the person that I would have to do this is with Treasurer.
No.
Okay. Can you get Eric to hold my hand here for a minute? So who would you make trustee in this situation?
I don't have to make a trustee. The trustee's already been made. You just need to find out who that trustee really is.
Well, if I scratch my head any further, I'm going to go bald. You got me, Christian.
Okay.
I didn't know I was coming in on a pop quiz tonight.
Well, maybe we'll throw the question out there to other people. Maybe they'll come in and say who they think the trustee is.
I'd like to hear other people try and figure that one out, too. So let me back off and let them come in, and they can scratch their bald head.
Okay. Okay, anybody else got a question? Maybe they can answer who the who the trustee is. Press star 6 followed by 1. Press star 6 followed by 1 to raise your hand if you got the answer to who the trustee is. Anybody? Star 6 followed by 1. Star 6 followed by 1. Got an empty board here. Nobody knows or nobody wants to say. Then state your reasons why you say so-and-so is the trustee.
Christian?
Yes. Who's this?
This is Carl.
Hi, Carl.
It depends on which trust we're talking about. If you're talking about the most fundamental trust, then depending on your background, it would probably be God is the trustee, and there is an accounting, but it's beyond the IRS. But I think if you're going to be on this earthly plane right now, I would say the Queen is the trustee, and that we're all looking to her for, or it could be the Vatican. It depends on how you're.
No, the Vatican and the Queen's trustee is the receiver.
Okay.
And God is not the trustee. You are the trustee. God's the beneficiary. He gets all the glory.
Well, he gets the glory, but we get the benefit of being in this world as
stewards.
Okay.
We got the responsibility, the duty. That's what he places upon us. He's grantor, he's beneficiary. He grants for his benefit.
So we're the trustee.
Yeah, we're the trustee in his kingdom, yep.
All right. So in that kingdom, so in the other kingdom, which I think is the one you were talking about with Albert, you don't think it's the Queen or the Vatican, it's some other worldly entity, IMF?
Yeah, the Queen and the Vatican, they're looking out after their assets because they want payment. They're looking for the credit. They're the creditors, and they've appointed the receiver to watch out for the assets to make sure they don't go anywhere, and they put a block on it. They put a block against the trustee, who is the real trustee holding the assets, and that would be on that main master strawman trust account.
Well, I know it's not the guards at Fort Knox.
No.
So eventually we'll knock out all of the people that it's not, and whoever's left standing, however ridiculous, is the trustee.
Well,
that was my guess. I guess I don't win the prize.
You need to. There's evidence out there. From the evidence, you can determine who is the trustee.
Well, your mother granted the signature on the birth certificate, so maybe it's your mother.
Well, that might have been first before this protective trust went in place. Who's the trustee on the protective trust over the
protective trust over what?
Over all the assets.
All earthly assets or all personal assets?
And that was the reason why 1933 had to take place, because the creditors weren't paid. And in order to stop the creditors from coming in and seizing the assets, they put all the assets in trust. That's what happened in 1933. They put them into a protective trust.
So you're saying who is the current trustee that all the assets are being controlled by, and you're thinking that maybe it's like China or one of the big creditor nations?
No, the creditor nations are coming through the receiver. See, nobody can touch those assets because those assets are in a protected trust, period. Until that protected trust, for some reason, its purpose is fulfilled or somehow it gets terminated. Then the receiver's got to make sure that he seizes the assets and distributes them to China or the UK or the Pope, whoever the creditors are. See, to stalemate the creditors, we formed a protective trust in 1933 so that the creditors couldn't seize the assets. Beautiful move, if you understand what happened. Now they can't get at the assets. Assets are being held in protective trust. And the only thing being paid out of the trust is per the discretion of the trustee. And now we know why debtor-creditor doesn't work, because they're not allowing it to work because it's per a discretionary trust to say you're going to let 10% get through.
Well, my limited understanding was approximately every 70 years there was a new bankruptcy and new collateral was given up. So if that's the same set of bankruptcy and trust set up.
Start with some new thinking and say, okay, where was this 70-year scenario coming up from? Public policy, debtor-creditor? If 70 years is a definite time, that's a limitation. Is there any limitation under equity? And where does limitation come from? Limitation comes from statutes and codes. Why? Because they want to put a limit on it because they want to get it. But under true equity, there is no limitation, and they can't ever get it.
So you're not talking about a statutory trustee, you're talking about an equitable trustee.
Yeah. Because all this other stuff about 70 years bankruptcy and all this and that is all statutory, which is limitation, so when the bankruptcy runs out, then they can come and put their hands on it.
Well, then wouldn't the trustee be the Declaration of Independence? Wouldn't that document set up the equitable rights?
Yeah, but that didn't happen in 1933 when the protective trust went into place.
So you're saying there's a new equitable trustee in 33 that is different from the one in 76?
Well, they put this 1776 assets into trust in 1933 and put a protective trust over it.
So the question is, who is the trustee over that protective trust? And that's got to be the fellows from Georgia there, the Federal Reserve, or what became the Federal Reserve.
No, they're just a bank holding the assets.
All right. Well, I'm just guessing at this point, so I'm going to give you back the airspace.
Yeah, you got a bank that holds the assets. You got an accounting, the IRS, who's a master accountant of the whole thing. Then you still got a trustee. Then you have a receiver over the trustee, and then you have the creditors. And
so if the Queen and the Vatican are the receiver...
Everything's balanced in a stalemate.
So you're saying that the Queen and the Vatican are the receivers above the trustee, between the trustee and the creditor nation?
Yeah, they're on the other side of the receiver, the creditor side. They're making claims that they are owed the money.
So somewhere between the IRS and the Queen, there's a trustee.
Yeah.
And it's not Ron Paul.
No. No.
Okay, well, I give up. I'll listen.
Okay. Thanks for your input. Anybody else? *6 followed by 1. Darren, you're unmuted.
Yes. Let's see. Do I have to do it in the form of a question? No, I'm kidding. I would say it's the state. I say the state is the trustee.
State of what?
The state that you're domiciled.
State of mind?
No, the actual state, the corporate state. Because the corporate state can't function even through that federal act without the act of federalism or the Reconstruction Act that allowed them to impose their duties through the state, because technically the state is the taxpayer and is operating as trustee.
Kind of right.
I'd like to buy a vowel. I'm thinking it's the state. The state operates exactly like that, but the question is it the state of your nativity or probably the state of your most recent domicile? Because you could have multiple residences but only one domicile. And I would say it would be the state unless it's broken down even further to the county commissioner or county commissioner on the county level, at a local level.
State of mind?
Well, that comes to let's say, well, if it's state of mind, you don't really want to go there, because then you start coming up with all these pondering thoughts, and sometimes that takes you in left field. Let's see. I'm just trying to think where. I'm just thinking it has to be the state, because the state is really the agent for the Fed. They're really the agent for the Fed more than anything else. But if it's a state of mind, hey, sometimes the mind, for some reasons we don't necessarily understand, decides to go to the store for a quart of milk.
Might be that,
I don't know. I'm thinking.
Might be that the Feds are the agents for the trustee.
Possibly. Would it be the Social Security Department?
No, it's not Social Security. I mean, we're just throwing out guesses, But
yeah, I'm thinking it's the state. The state would come to be my mind.
It's
because really that's always the interacting party.
Well, anybody else?
The only guess I have, really.
Okay.
Okay. Thanks.
Any other questions? That's okay. Got anybody else? Anybody else? *6 followed by 1. Don, you're unmuted. You're unmuted, Don.
Oh, I'm sorry, I didn't hear you. I thought I'd contribute a little bit to the conversation of who the trustees are, or the trustee of the straw man. Would that not be your elected officials in the government, like Congress, Senate?
That's a question.
Beg your pardon?
That's a question. I was looking for an answer.
Well, that's my. I think you talked about that before, and I think you had mentioned it. Our public officials, Congress, would be the ones who are administering trust, and they're the ones that make up the rules as far as how it's administered, aren't they?
I think that's the Congress and or the House is really they're setting up the rules to be broken that are going to take and provide the income, because we don't have any income in this country. So they're creating the statutes and codes, which becomes the bond that if you break the bond, you get charged with, the obligation for the fee that they're going to charge you for that breach of that statute and code. That is the money that gets slipped under the table, because now it's like a criminal charge, and it doesn't get treated as a tax, because all the taxes goes as fees to the Queen and the Pope. So they don't they can't get that money, so they don't have any money to operate with. So they have to come up with, through the House and the Senate, the statutes that proves the amount of money that they get from the breaking of the statutes that keeps the country going. It's prison for profit, because they can't touch the assets from the taxes, because that all that stuff is just interest. That's the use that goes right back, and the United States can't touch that. The country can't have that.
Right. So now we go back to the Queen and the Pope. Now, does that not go back to these ancient trusts called custody or KV trusts that they put out, claiming your property, your body, and your soul?
Well, it comes back to that the Lord is in by his cheat, yeah, which is not right.
Yeah.
It comes back to what I say, that there's been no perfect title granted to this country of any property, because the Queen still retains the beneficial title, the beneficial interest, and the right to take. And ever since 1776, we've been passing along legal titles without consideration for the beneficial interest.
Yeah. Well, now, when you say the Queen, how did the Queen acquire title to all of the property when Spain was involved, France was involved, Russia was involved?
The king or whoever, the queen or whoever has got the beneficial title is in by his cheat originally, which was wrong, really.
So they're claiming title to something they had no right to claim title to.
Yeah, because really it's supposed to be we the people. The people are supposed to be the beneficial owners to it, beneficial title. But at the formation of this country in 1776, I don't think there was any perfect titles. That's just a misnomer. All we had was legal titles, because that's all we were granted.
Well, what about the native or indigenous people? Would they not have had their own? Did they not come up and
They don't make that claim. They don't make that claim. They've been beat up enough.
Yeah.
They've been treated to death.
Well, they say it rather eloquently in Native American that the white people spoke with forked tongue.
Yeah, well, there was misconstrued under duress again.
Yep. Can they not go back and reclaim?
Sure.
I would think that would be what the natives should be doing.
I think so too.
And tell those forked tongue white people to leave.
So anyway, not to start a guessing game, but anyway, we got any other questions pertaining to NTT more on the line? Or?
Still digesting with the information that we discussed this evening. There's some really, really stuff there that hadn't gotten that far into it to really digest it. So we'll be busy for a few days working on that.
Okay. Yeah, keep it in general.
Oh, well, going to court tomorrow to talk to the judge concerning the dismissal of the bankruptcy. We're anticipating that maybe they want to dismiss it to let the trustee off the hook who has repudiated her position of trustee after returning the trust res and the indenture at a very late date.
Yeah, but I wouldn't allow her to repudiate. I would, I think in the last message I sent you there, did you get that one?
Yeah. So you think we need to remind her that she waited long?
Yeah. Just the fact that you turn the res back does not mean that you're not the trustee. You've gone past the time to disclaim, and now the trust is effective, and you're trustee. You're in breach of trust.
Yeah. Well, you think that if they dismiss Chapter 7, that will affect the adversarial claim?
That I can't answer. I'm not sure of that. You'd have to find out from the court, maybe. Maybe that's the ploy they're using to get rid of the adversarial claim. Because when they close the bankruptcy down, maybe the adversarial claim closes down too. But it depends which way you're looking at it. Actually, it's like two separate courts. Federal bankruptcy is one thing administered by the federal jurisdiction, but then federal court might be independent. So it might be two separate ones. Who knows? You'll have to check someplace other than... I can't answer that.
Yeah. Well, right now they're choking us now, so and they won't let you do anything to pay off the whole bankruptcy or do none.
They say what again?
They're saying you've got to pay off the whole bankruptcy before they'll do anything as far as release the stranglehold on them.
We already have.
So they've got everything tied up.
You issued an equitable asset against the debt. The debt should have been terminated, but the trustee is not ledgering the account as being paid. In breach of trust.
Does that make her liable for damage?
Yeah, but I think you're all off on the wrong foot. It's like you're topsy-turvy. Got to establish the validity of the trust first. Establish that there was, make a claim that there was a breach of trust, and get an order for a decree on that. Now you got a valid trust with court recognition, and a breach. The trustee's in breach. It's like you're trying to do the third or the fifth step when you haven't done the first and second, And you got to go back and do step 1 and 2 first.
So we're thinking maybe it might be best to get out of the bankruptcy and go back and try to do that in this court. Otherwise, we're up a pole and
Right.
kind of the upper hand. What about the possibility of putting your trust document and what have you into a probate court ex parte and have the court recognize or rule on the trust from that avenue?
I don't think the courts like to do ex parte hearings.
Even though it's on a trust?
The only thing to do ex parte is maybe on a family matter that somebody's being harmed, they'll issue an injunction against somebody, for bodily harm or something. Irreparable damage that way. Courts normally don't do ex parte. Now, you could do a hearing with the other party.
Isn't that the responsibility of a probate court or a judge to determine whether a trust exists, and if not, to screw a trust? That is, if there's a disease.
Yeah, if you could prove that there was absconding with the funds and a conversion was done, somebody ran off with the assets, yeah. But then it's the proving of the trust first, and then once you got a trust, then the burden of proof shifts to the trustee. And once you've made a prima facie case that he's breached, then that equity looks at it as, yeah, he's breached. He's guilty. And he has to come up with a record to prove that he's not guilty. So that's your main focus. Prove the validity of the trust so you can come in and make an accusation that he's breached trust. And once you've done that, the onus of probandi shifts, and the court of equity is going to look at the trustee as being guilty already. The only way he can prove he's innocent is if he's got a receipt for the disbursement of the trust or the performance. And you got him.
Anyway, that's great. We're going to see what happens tomorrow, and then we'll know where to go from there.
Uh-huh.
Bone and the attorney lawsuit Did you hear that?
It was kind of muffled.
Well, he wrote a letter. The trustee asked for a hazardous bond and the number or the certified copy of her bar license. She wrote back and said that those requests were improper.
What was that? Well, see, that's an NOI. Now, where's the SOI to support that?
Yeah, I guess that's the question. Where's law?
Well, what you can do is you write back. You tell them, hey, you didn't explain why it's improper. So hereby, I object to what you say. That's not so. It's stricken. What you said is stricken.
Yeah.
There's no supported claim to what you just said.
Well, and we got the same sort of letter back from the state, sending the lawyer for the ADF&A saying basically the same thing, that they didn't have to answer anything like that, and that the state court didn't issue bar license.
Well, then what's the purpose of the bonds then for?
Well, they're pretending like there is no bond. There's nothing exists. They're denying it.
Well, then I guess they're personally liable then.
Yeah. Well, in a case like this, and if you don't get a certified copy of, say, they don't have a license, can you not put their bar card number on a piece of paper and create the title and then merge it, send it in?
Better than nothing.
So that it's no longer terminated?
Yeah.
And notify the bar that it's been terminated or it's been merged, terminated?
Heck, send that stuff to the DTC.
The merged titles?
Yeah, now you notify the DTC, who is the system of record keeping for the commercial transactions, and now everybody's been notified that does a commercial transaction that number's no good anymore.
Yeah. Christian, I will read you what the DFMA attorney said. Turning your request certified copies of public hazard bonds held by Mr. Hoffman and Mr. White. You should be advised that neither the Arkansas Code nor the Separate Code requires either individual to obtain a public hazard bond. In point of fact, I can find no reference to public hazard bonds to either code. Accordingly, we cannot respond to your request without certified copies of said bond.
What was it that you asked?
I asked them for the public hazard bonds along with their law lots, certified copies.
And you should have said, if they have none, state that you have none. See, they really didn't say that they don't have one. They just said, we can't see the law where it was. It's okay. Now you got to come back with the law that says they got to have one. Find the law that says they got to have one, and write back to them and said, this law says that you got to have one. You don't have one.
I may know what I'm up to. If he were to, say, terminate their law license, terminate their bond, is there any recourse that they can do to reestablish it, or do they have to go back and...
They could arrest somebody on false presumptions for anything or for spitting on the sidewalk. It's whether or not you can defend yourself.
Well, if they come at you with a charge, don't they need to prove it?
That's under equity, but they're not operating under equity. They're at law, and at law, they don't have to prove nothing. They just come up with a presumption. We don't want to go in that at law side, because if we do, that's a realm we don't understand. It's against all our thinking that we've been taught. It's not equitable. It's not but they don't have to be equitable because it's not an equitable realm. There's no equity in it. Here all along, for all these years since 33, we've been coming into this ad law side getting creamed, and we keep on coming back into that side and getting creamed. Now we want to stay out of that side.
Exactly.
Can't win in there. They even say there's no adequate remedy at law. So how do we get in a court of equity?
Well, you wouldn't want to terminate their bonds, their license, eh?
Yeah, I'd want to terminate it under trust. That would zero it out. But then, trust is enforceable in equity, so it comes back down to equity.
So if you did terminate it under trust, do they have recourse other than coming at you at law?
Shouldn't.
Or are they out of business?
Should be. They can always come at you with anything.
Beg your pardon?
They can always come at you for anything.
Well, we saw that when they came after one of our friends filing the UCD. So
It comes back to, can you enforce what you know? Can you defend yourself? Like they beat you up for making the proper claim, but then they're counting on that you don't know how to defend your claim and you lose your claim. So therefore you have no rights. You're just a total slave.
Yeah.
Some justice.
So that's where you need to know your rights and know how to act.
Yeah, and if you know your rights, then you know that your rights are only enforceable in equity. But yet we keep on trying to bring our rights into at law, and we keep wondering why we get hammered. Yeah, at law side fictions.
Meat doesn't have rights. No chance.
Yeah, fictions don't have rights. They're slaves. Only real people have rights, but those, we keep on going in the wrong courts, and we should be going in the court of equity. And we've lost the knowledge of how to do that, and now we're trying to get it back, and that's a lot of sifting through a bunch of garbage to finally get to find out where the key's at. We lost the key.
Actually, we lost combination.
Yeah, well, the key is really the relation. It's a trust relation. And the combination of the trust, to make the door work right, so to open the lock, we need to put on the eyes of equity so we can see clearly. You read the Maxey Center case, there's, without a doubt, two separate jurisdictions, two separate venues in one court administered by one judge, gotten into by one set of procedures governed by two sets of forms.
Now, once we get our bills and excellence written up and get them satisfactory to our liking, we're going to be putting them in the court via the clerk and requesting that they be put under an equitable docket, or how might we, because normally at the at-law side, you take in the clerk just stamps them and throws them in the shelf for a while.
Yeah, I don't know if the court, if the clerk has both sides of the docket. Maybe the clerk has the at-law side docket, and maybe the judge has the equity docket. I don't know.
So that mean that, or imply that you would need to send your bill and equity to the judge? And if you've got an ongoing case, you pull it into equity, putting your bill and equity in, are you going to put a cover sheet over the top of bill and equity?
Well, I don't. These are the things I can't quite answer just yet, because we're just not quite there yet. One time the clerk had both equity and at-law side dockets. Now, I don't know whether, since maybe nobody has been sending in an equitable bill in chancery for so long that the clerks have forgotten because they've never entered in anything on the equity docket for the last, say, 30 years. And nobody remembers there how to do it because nobody's ever accessed it, and they've just kind of lost it too. I don't know.
There's amnesia on both sides.
Probably. I mean, some of these judges act like they never heard of equity.
Yeah, we saw that.
They thought you're nuts.
Yeah.
Until they looked at the Maxey Center case and some other information and said, yeah, I see your point. You're right. We may have re-education on both sides.
Yeah.
And that's when we stop acting like fictions. And we reach the age of majority because now we're trying to come back to doing government. Acting as the sovereign people instead of some person.
Well, there appears to have been a concerted effort to wipe that from the conscious of the psyche of the conscious human.
I would say so.
And they've done a pretty good job of it. Except for the fact that a lot of people running around thinking, having that feeling that there's something wrong, can't put the finger on it, they know there's something wrong.
Well, we've given the reason what's wrong, or the answer to what's wrong, excuse me. Has any knowledge of equity any longer.
Yeah.
I think that the results of them combining the courts to where one judge gets to administer both sides, equity and at law, I think that judge is really not qualified to do that. This is the age of specialization. They should have a judge that specializes in the two types of law, and that's just exactly what these older advocates of equity were saying before they merged and while they merged these two venues or in a process at least. That's what they were afraid of. And that's exactly what's happened.
Exactly. And they've abandoned completely the whole concept of equitable principles and gone with the outlaw. And there's no conscious law.
I don't know if I could say that they have abandoned. We have abandoned.
Yeah. Well, we don't know what to ask.
Well, that's true. Yeah, we don't know what to ask for. Yeah. But if we would have been doing government from the start, we may never have lost it.
That comes with what's being taught in the school, and if they take that out of the school, then how are the people to know what they need to know if it's not being taught?
Well, they keep feeding us with drugs all the time, opiates, and making our minds go to sleep so that all we can do is, we'll take care of you. We'll take care of you. We'll be your servants. We'll take care of you. Go to sleep. You're getting sleepy. We'll take care of you. Go watch your TV. Drink your beer.
Be happy.
Be happy, yes. We will run everything for you. You think that the chickens guarding a chicken house wouldn't steal some chickens? If nobody was watching the chicken coop and guarding the guards that were supposed to be watching? Do we really think that sinful people appointed to be servants of government are going to administer a perfect government? From the same sinful mold everyone was made, and yet we expect that the government's going to do things perfect when the government's made of the same sinful people.
Yeah.
Did you really think that if they ever had the opportunity, they wouldn't run away with the chicken coop?
Yep.
No, I think I should have been. If I'd been watching, it would never happen.
There was a movie that was done in Germany. I don't know. Have you heard of it called The Experiment? Familiar with that?
No, but the one I like is Nanny McPhee.
Oh, yeah, that's a good example. Whenever they're no longer needed, it's no longer there.
Yeah, now why wouldn't they no longer be needed?
Well, they the age of majority or become conscious of their what they're doing.
Yeah, who they really are. They become conscious of who they really are, and they don't need because they're doing what the other person is doing for them.
Right.
So when we start doing government, we will no longer need servants of government. We will be the government. We don't need any servants.
Right.
That's all we need to do. We just need to wake up.
Did you notice how Nanny transformed from the ugly-looking nanny to the woman at the very end?
Yeah. Mm-hmm.
She left. Well, the reason I mentioned
the statutes and codes. The statutes and codes are designed to beat you up for a purpose because it's the tutor putting you between a rock and a hard spot and beating you to wake up. Wake up to the fact that you need to be doing what you need to be doing, and you wouldn't have any need for the statutes and codes, and they wouldn't beat you up. It's all the same thing. Nanny McPhee, all this, but we must learn the hard way. God's going to put the whole world into a wine press to the point to where you're going to want to crawl into a cave and let the rocks fall on you to wake you up to the fact that you need to be doing something. And then you will be ready to accept His kingdom. Sad how far we have slipped into the dark ages, although we have all this high technology stuff that is really a diametrically opposed scenario.
All this high technology just makes it easier for them to act the reign.
I don't know. There's a lot of technology available to us to get smart with out there. Well, anything else?
Oh, no, I think that's it. Did we answer the question of the trust?
No.
Well, I know that we are.
Yeah, right. Yes, correct.
We are actually. Who is holding the title?
Yeah, somebody has repudiated, so they.
I'm very sure the state registrar of the birth.
What? Say that again.
The state registrar of the birth would be the holder of the title, original.
They may be just nothing more than the agents that were the mechanism that formed it per our authority.
What about the Depository Trust Corporation?
No, they're just an entity to speed up commerce under the what do they call it? The holding system. They keep everything in house so they can do it all by computer transaction from account to account. It's all done by per UCC Article 8 and 9.
I got a ball spot.
Have what?
I have a ball spot now.
Okay. All right, so we'll give somebody else a try to.
I'll check with you.
All right. Anybody else have a question? Press star 6 followed by 1. Star 6 followed by 1. Anybody? Okay. Star 6 followed by 1. Anybody? Going once? Going twice? Going 3 times? Last call. Okay. Today is Tuesday. We'll see you tomorrow on the TalkShoe number at 8 p.m. So everybody have a great night. See you then.